The right of asylum for victims of political persecution is a basic right stipulated in the German Basic Law. In a wider sense, the right of asylum recognizes the definition of refugee as established in the 1951 Refugee Convention and is understood to protect asylum seekers from deportation and grant them certain protections under the law. Generally, these protections are a part of the asylum procedure itself and are verified by the Federal Office for Migration and Refugees without any further application. In 1993 and 2015, the initially unlimited right of asylum was revised in essential points and also limited, in light of the refugee crisis in the second half of 2015. A transformation of the fundamental right of asylum into an objective guarantee was demanded in order to give the state the legal opportunity to impose an upper limit to quota. Asylum and refugee status. The German Residence Act only regulates refugee status. Neither the Residence Act nor the Asylum Law defines the concept of asylum. Its content and limitations are primarily a result of the court ruling by the Federal Constitutional Court concerning Section 16a-GG in the German Basic Law. In accordance with Section 16a-GG, a person is considered to be experiencing political persecution if he or she is suffering from infringements of his or her rights by the state or third-person measures that can be attributed to the state, because of religious or political convictions or other inaccessible features that mark the individual's otherness. These infringements of the personal rights violate human dignity and, depending on their intensity and severity, exclude the individual person from the state's general keeping of the peace and put him or her in a desperate situation. More commonly, politically persecuted people are granted protection based on the Convention relating to the status of refugees. Although the Refugee Convention has been valid in Germany since the 24th of December 1953, the German legislature often did not consider it necessarily to grant refugees full refugee status. Instead, it simply granted them a recognition of asylum. This procedure only changed with the Qualification Directive and a law that was passed along with it in August 2007. Today, official refugee status is conferred on refugees, in addition to the status of being entitled to political asylum when necessary and Asylum Procedure Act. Now, refugee status is equal to the status of a person entitled to political asylum in regard to the right of residence. Furthermore, admitted refugees have no disadvantages compared to people entitled to political asylum concerning social benefits, participation in the employment market and the granting of travel documents. For more information concerning the definition of refugees in Germany, see the German article on Flüchtlingseigenschaft. The asylum law regulates the administrative proceedings that grant the asylum seeker the status of a person entitled to political asylum. During the asylum proceedings, the asylum seeker receives temporary permission to stay. Application procedures. To file an application for asylum, refugees have to personally register in one of the German reception centers. Here, the country of nationality, number of people, sex, and family ties of the asylum seeker will be recorded with the assistance of the EASY program. This then determines which reception center is most able to take care of the refugee. The refugees have to go to the assigned center and after being admitted they must apply for asylum personally at their assigned federal agency office as soon as possible. In Germany, applications for asylum are processed by the Federal Agency for Migration and Refugees. Section 13a defines the application for asylum as follows. An asylum application shall be deemed to have been made if it is clear from the foreigner's written oral or otherwise expressed desire that he is seeking protection in the federal territory from political persecution, or that he wishes protection from deportation or other removal to a country where he would be subject to the persecution defined in Section 3, a serious harm as defined in Section 4. Every application for asylum shall constitute an application for recognition of entitlement to asylum and to international protection within the meaning of Section 1. No. 2. The foreigner may limit the application for asylum to the application for international protection. He shall be informed of the consequences of such limitation. Section 24 shall remain unaffected. Any foreigner who does not have the necessary entry documents shall apply for asylum at the border. In the case of unauthorized entry, he shall immediately report to a reception center or apply for asylum with the foreigner's authority or with the police. Section 14 Asylum outlines the application procedure. After application, the asylum seekers will receive a temporary residence permit for the duration of their asylum procedure. Section 16 Asylum states that every refugee's identity must be recorded. Only children under the age of 14 are exempt from this rule. Holders of a temporary residence permit are not allowed to work within the first 3 months after receiving the permit. After this time, they are allowed to apply for a work permit, which can be granted by the federal agency. However, holders of temporary residence permits will only receive secondary access to the labor market. In accordance with Section 14A Asylum, the procedure can vary greatly if it falls under the so-called airport procedure, an altered jurisdiction for refugees traveling to Germany by plane and applying for asylum before entering German borders. In short, it states that refugees may be processed within 3 days, and be sent home much quicker if the police can determine that the refugees started their journey in a country previously defined as safe by the German government. The law was put in place to keep airports from having to house refugees for extended periods of time and potentially becoming overrun while refugees waited for their application for asylum to be processed. Processing applications for asylum are processed by the Federal Office for Migration and Refugees. According to Section 10 of the Asylum Procedure Act, asylum seekers are required to disclose any change in address to the aforementioned migration agency without delay for the entire course of their asylum in Germany. This also applies to any move that was dictated or enacted by the agency itself. The most important aspect in gaining asylum is the official hearing in front of the Migration Office. In the summer of 2015, the average processing time of an application for asylum was 5.4 months, as reported by the Migration Office (BAMF). However, experts claim the number is actually significantly higher, closer to 1 year. The difference in these figures is said to be due to the fact that BAMF measures the processing time starting at the moment an asylum seeker files with the Migration Office. This can be many months after they enter the country. Furthermore, the office processes those applications which are easier to decide on more quickly, putting them in front of a pile of about 254,000 unprocessed applications. Applications to be disregarded. Section 29 of the Asylum Procedure Act constitutes that an application for political asylum has to be disregarded if the asylum seeker can be removed into a third country where he or she is safe from political persecution. Manifestly unfounded applications. Section 29 of Asylum determines how to treat an asylum seeker from a safe country of origin. His application shall be rejected as manifestly unfounded, unless the facts or evidence produced give reason to believe that he or she faces political persecution in his or her country of origin in spite of the general situation there. Section 30 of Asylum sets forth further terms about when an application has to be rejected as manifestly unfounded, and Section 36 determines the following proceedings for these cases. An application that has been rejected as manifestly unfounded has a barrier effect as long as the rejection is justified by Section 38. Since with regard to Section 10 Act on the residence prior to leaving the federal territory no residence title can be granted, an exception is granted when an unsuccessful asylum seeker is otherwise entitled to a residence permit. One common example is when an asylum seeker joins a German family Haufen. The German Bar Association demands the second sentence of Section 10 Haufen be removed, because its barrier effect, which prevents refugees from receiving a permanent permission to stay, results in the office granting temporary residence permissions multiple times despite integration efforts. Other arguments include that the section conflicts with European and international laws and is an unjustifiable discrimination compared to expel foreigners. False or incomplete information. False or incomplete information that is given on the asylum application and any following inaccuracies can lead to significant consequences for the asylum seeker, according to Section 30 ASYLG. This especially concerns false identity information, which can make procedures like weddings, childbirth, or targeted naturalization more difficult or even impossible until correct information can be clarified. Additionally, if these untrue personal details are also intentionally used apart from the application for asylum, criminal liability according to the Act on Residence can come into consideration. If the foreigner is able to clear up the facts after a successful application, the asylum which is based on incorrect or incomplete information will usually be considered for a possible revocation by the Federal Office for Migration and Refugees. Parallel to this procedure, the authorities can, if necessary, make further decisions and can even disregard deception which was relevant for the right of residence, a deception for the right of residence which was used a long time ago. The verification can, however, also lead to a deportation. In some federal states of Germany, false or incomplete information can exclude a consideration of the Hardship Commission. Otherwise, false or incomplete information for relevant questions for the decision can also lead, according to the European secondary law, to revoke or deny renewal of the legal status as a refugee. Legal prosecution. If asylum seekers enter the country without the required visa, they cannot be prosecuted for this action according to Article 31 of the Convention relating to the status of refugees, provided they present themselves to the authorities without delay and show good cause for their illegal entry or presence. Furthermore, a common legal opinion is that a clearly unfounded application for asylum does not automatically represent an abusive misuse of the law. This would only be the case if purposeful, abusive activity can be proven. Contrary to common belief, false or incomplete statements during the process of the asylum procedure are not immediately prosecutable. Furthermore, the Residence Act does not apply during the first asylum procedure. Thus, punishability according to Section 95 and section of the Residence Act does not apply in this case. The German legislature has also intentionally abstained from defining a legal norm of penalization in the asylum law. Asylum seekers will only be prosecuted in the following cases. If they used fake or falsified passports, they could be prosecuted according to Section 267 StGB. Also, if they use falsified personal data in their residence permit. However, merely making false statements during the asylum procedure does not qualify as a criminal offense and is regarded as an administrative offense. The The aforementioned criminal offences of the Residence Act can only be fulfilled if false statements are made and used in following lawsuits concerning the rights of foreigners. A decree released by the Ministry of Internal Affairs and Justice of North Rhine-Westphalia states that false or incomplete statements are the submission of false documents during official asylum procedures conflicts with public interest because it raises public expenses and could tend to encourage xenophobia and the formation of criminal organizations. These actions shall in retrospect lead to expulsion according to Section 55 of the Residence Act. Also, since the 1st of November 2007, Section 96 penalizes the use of false identification documents with the goal of suspending deportation. Thus, false or incomplete statements will be punished with prison sentences of up to 1 year or 3 years, according to the Residence Act. According to Section 84 and 84A, attempting somebody to make false statements while applying for asylum is prosecutable as well. Revocation procedure. Until 1 August 2015, the Federal Office for Migration and Refugees was legally responsible for checking that a positive decision was still valid no later than 3 years after the decision was made. One criteria for revising the decision would be a felony that was penalized with more than 3 years in prison or a crime against peace. If an infringement is found, the Foreigners Registration Office reviews the claim to residency. Under certain circumstances, such as a complete lack of integration or a severe felony, the residency is ended. If the protection of the Federal Office for Migration and Refugees is not revoked, the refugee is granted a permanent residence permit. In practice, it has been granted to 95% of all refugees. The renewal of the asylum law, which became effective on the 1st of August 2015, is supposed to cut efforts for the Federal Office of Migration and Refugees on individual assessments. The Foreigners Registration Office is allowed to grant the right to stay after 3 years. If the Federal Office of Migration and Refugees does not give notice of an exceptional case that justifies the revocation of protection, extensive individual assessment of applications of asylum with personal hearing which have been agreed on by the Conference of Ministers of the Interior in Koblenz on 3 December 2015 are part of the procedure since 1 January 2016. Applications from refugees from Syria, Iraq, Afghanistan and Eritrea processed like that for safety reasons. Development in the volume of asylum applications and the rate of success. Volume of asylum applications. Before 2015, the previous peak in the number of applications for asylum was in 1992, when over 400,000 applications were received. At the time, most applicants came from the former Yugoslavia. However, after 1993, there had been a continual decline in applications. In 2005, for example, 29,000 applications were received. The number of first-time applicants continued to decrease throughout 2007, when Germany saw only 19,164 applications, the lowest amount since 1977. Since 2008, however, the number of applications has started to increase again. In 2014, the highest amount since 1993 was recorded. The reasons for this increase included the surge in asylum seekers from Serbia and Macedonia as a result of the abolishment of the visa requirements for both countries in December 2009. In the first half of 2013, the number of first-time applications for asylum increased 90% when compared to the same period in the previous year. The majority of the asylum seekers in this year came from Russia, followed by Syria and Afghanistan. The Federal Office of Migration and Refugees expected 450,000 applications for asylum in the calculations for 2015. based on the number of applications they received in the first half of the year. In August 2015, however, the Federal Ministry of the Interior corrected this number, claiming up to 800,000 applications. Data released by Germany's Federal Office for Migration and Refugees in January 2016 showed that Germany received 476,649 asylum applications in 2015, mainly from Syrians, Albanians, Kosovars, Afghans, Iraqis, Serbians, Macedonians, Eritreans and Pakistanis. Success of asylum applications. In 2014, 202,834 asylum applications were filed in Germany. 128,911 decisions were made. 1.8% of the applications led to a recognition of refugee status according to Article 16 AGG. Another 24.1% were recognized as refugees from Section 3 ASYLG. 4% received subsidiary protection of Section 4, and 1.6% were granted a prohibition of deportation. Therefore, 31.5% of all applications were successful in the broadest sense. 33.4% of the applications were rejected after substantive examination. Following the calculation of charity organizations, Germany has an adjusted protection rate of 48.5%. If successful legal claims against the decisions of the office are counted as well, more than half of the refugees were granted a status of protection in 2014. In 2015, Germany made 282,762 decisions on asylum applications. The overall asylum recognition rate was 49.8%. The most successful applicants were Syrians, Eritreans and Iraqis. Of about 200,000 people who were legally bound to leave in 2015 after their applications for asylum had been rejected, only 20,914 were deported. A major obstacle for deportation was the lack of cooperation from the home countries. In February 2016, the German government did send complaints to 17 nations who do not fulfill their international obligations and insufficiently cooperate, either by not helping to identify their own citizens, by not issuing ID cards for those whose asylum applications have been rejected, or by taking only those people back who voluntarily leave. Those nations are, in Asia, India, Pakistan, Bangladesh and Lebanon. In Africa, Algeria, Egypt, Morocco, Mali, Nigeria, Niger, Ethiopia, Tunisia, Ghana, Guinea, Burkina Faso, Benin and Guinea-Bissau.